Went to the Supreme Court today in person to hear the arguments over the Voting Rights Act, the cornerstone of American civil rights law. It was kind of an amazing experience. Here's a little of what it looked like outside the court before the arguments started. Watch.
Last year, the voter ID laws and the long lines and the ending early voting and the stopping Sunday to the polls showed that Jim Crow's son, James Crow Jr. Esquire, is still trying to do what his daddy did, and that's rob us from the right to vote.
James Crow Jr. Esquire, MSNBC's Reverend Al Sharpton, speaking at the protest on the courthouse steps this morning. People advocating that the Supreme Court leave the Voting Rights Act alone, arguing that there is still a need in this country for the protection it offers. When I got to the Supreme Court this morning to go inside and listen to the case, the first sign that I saw at the protest on the steps when I arrived was this one. I think we've got one shot of it, yeah. It says Martyrs. And the names there are Schwerner, Cheney, Goodman. Michael Schwerner, James Cheney, Andrew Goodman. We remember them forever as the three civil rights workers who were murdered, or maybe martyred, in Philadelphia, Mississippi in 1964. What we remember about them particularly today is that what they were doing in Philadelphia, Mississippi, what they were risking their lives for, and what they ultimately gave their lives for, specifically, was voting rights in Mississippi. They were registering people to vote, registering African Americans to vote as part of an effort called the Mississippi Freedom Summer. And they died for it. The man who coordinated Mississippi Freedom Summer for SNCC, for the Student Nonviolent Coordinating Committee, was John Lewis. In March 1965, the year after Freedom Summer, it was John Lewis and Hosea Williams who led a group of 600 protesters on a march that started in Selma, Alabama. We also, as Americans, remember forever Selma. But what we remember particularly today about Selma is what they were marching for specifically, again, was voting rights. What they were trying to do was march nonviolently this distance from the city of Selma to the state capital of Alabama, to the state capital, which is Montgomery, about 50 miles away. They were stopped that first day when they were trying to march that distance before they ever got out of Selma. Here, trying to cross the Alabama River to get out of town, to get out of Selma, the 600 peaceful protesters were met by hundreds of Alabama state police and local police. The policemen attacked the protesters. They used tear gas on them. They beat them with billy clubs. The protesters were whipped and stomped on by police horses. The leader of the march, John Lewis, took a billy club to the head. He very easily could have died on that bridge that day. 17 of the marchers were sent to the hospital. That happened on Sunday, Bloody Sunday, March 7th. Now, I said that they did not get out of Selma that day when they were beaten on that bridge. But the nation was horrified, and the movement was galvanized. And 2 days after Bloody Sunday, 2 days later, on Tuesday, March 9th, they went back. Only this time it was not 600 people marching that route nonviolently. This time it was not 600, it was 2,500 people marching that same route. And they marched to that bridge again. And then a week later, they took on that march again. Only this time they were protected by thousands of U.S. Army soldiers and National Guardsmen acting under federal command. And by the time that march, ended up at the Montgomery State Capitol, it was not 600 people. It was not 2,500 people. It was 25,000 people. And that was when Martin Luther King Jr. gave his "How long, not long" speech at the state capitol. The night before that last march started, the President of the United States convened a joint session of Congress to address the crisis and to demand a very specific response. This is the night, of course, when President Lyndon Baines Johnson, in his Texas drawl, said live on national TV, "We shall overcome."
Mr. Speaker, Mr. President, members of the Congress, I speak tonight for the dignity of man and the destiny of democracy. At times, history and fate meet at a single time, in a single place, to shape a turning point in man's unending search for freedom. So it was at Lexington and Concord. So it was a century ago at Appomattox. So it was last week in Selma, Alabama. What happened in Selma is part of a far larger movement which reaches into every section and state of America. It is the effort of American Negroes to secure for themselves the full blessings of American life. Their cause must be our cause too. Because it's not just Negroes, but really it's all of us who must overcome the crippling legacy of bigotry and injustice. And we shall overcome. Every American citizen must have an equal right to vote. Every device of which human ingenuity is capable has been used to deny this right. The Negro citizen may go to register only to be told that the day is wrong, or the hour is late, or the official in charge is absent. And if he persists, and if he manages to present himself to the registrar, he may be disqualified because he did not spell out his middle name, or because he abbreviated a word on the application. And if he manages to fill out an application, he is given a test. The registrar is the sole judge of whether he passes this test. He may be asked to recite the entire Constitution or explain the most complex provisions of state law. And even a college degree cannot be used to prove that he can read and write. For the fact is that the only way to pass these barriers is to show a white skin. In such a case, our duty must be clear to all of us. The Constitution says that no person shall be kept from voting because of his race or his color. We have all sworn an oath before God to support and to defend that Constitution. We must now act in obedience to that oath.
And so, that was a joint address to Congress a week after John Lewis was nearly beaten to death marching for voting rights in Selma. And so, a year after the Freedom Summer, and its martyrs too, there was LBJ proposing the Voting Rights Act of 1965. And it passed, and he signed it into law. And the Voting Rights Act did not make it illegal to keep people from voting based on their race. That was already illegal. As LBJ explained in his speech, what the Voting Rights Act did was make that right not just legal, but true. It created a framework that could be used to force the parts of the country that weren't upholding that law to uphold it. A framework that could be used to force states and localities to do what the law already said they should do, but that they were not doing. The Voting Rights Act was created in full cognizance of, and in direct reaction to, the resistance in parts of this country to people trying to exercise this right to vote that they had in law but not in fact. And so the Voting Rights Act banned any sort of test or hurdle that you had to surmount in order to be allowed to vote. The Voting Rights Act in most parts of the country essentially gave you a grounds on which to sue in federal court if your voting rights were infringed. That was true for most of the country, but in parts of the country with a more horrible than usual history of denying people the right to vote based on race, in some parts of the country, special attention would be paid. Those places would no longer be allowed to keep moving the polling places, or closing polling places, or moving people in and out of voting districts, or changing the registration procedures, or changing voter ID requirements, or changing election dates, or anything else they could think of to undermine or thwart minority voting, while just hoping that they wouldn't get sued someday over it, but if they did, oh well, damage is already done. No, in states and in some counties and cities that had really earned it, those states would have to clear any of the changes they wanted to make around their elections rules with the feds. The same way those marchers ultimately got protection from soldiers and National Guardsmen operating under federal command. There were some parts of the country that would have to clear the changes they wanted to make to their election laws with the Justice Department ahead of time. And if the Justice Department said, okay, this will not adversely affect minority voting rights, then fine, they could go ahead. But they had to ask first. They needed pre-clearance from either a panel of judges or the Justice Department to make any changes. And that's because they earned it. Over time, some places were added to the original list of places that got special scrutiny like this. Other places have been able to get out of the special scrutiny requirement over time after essentially showing a long stretch of good behavior. But the principle that some parts of the country need special scrutiny to protect voting rights in those places, that is at the heart of the Voting Rights Act. Of course, it was challenged in court right away, and the Supreme Court in 1966 upheld it as an appropriate response for Congress to take, given the problems that we had to this, on this issue as a country. Initially, the special pre-clearance requirement was set to expire in 5 years. Well, when the 5 years were up, Congress decided to renew it for another 5 years. And when those 5 years were up, Congress renewed it for another 7 years. And when those 7 years were up, Congress renewed it for 25 years. 25 years, because by then it was clear that it was an effective way to deal with this problem in our country, and we should therefore keep doing it. When that 25-year extension was up, Congress again renewed it for another 25 years. That was 2006, when George W. Bush was president. Congress held 21 hearings over 10 months of debate. They took in 15,000 pages of evidence on whether this was still needed. And after all of that, they voted nearly unanimously to keep doing it this way for another 25 years. In the Senate, it actually was unanimous. It was a 98-0 vote in the Senate. Well, today, Supreme Court Justice Antonin Scalia asserted in court that those 98 senators did not actually want to vote for the Voting Rights Act. He says they didn't actually mean to vote that way, and that we should not see their votes for the Voting Rights Act as votes for the Voting Rights Act. He said that the 98-0 vote in the Senate was actually just a sign that people see voting as some kind of racial entitlement now. That was the phrase that he used, racial entitlement. And yes, people in the courtroom gasped when he said it, and it seemed like he likes it when that happens. Justice Scalia said that his concern was, quote, that this is not the kind of question you can leave to Congress. Because Congress might vote for it unanimously after 10 months of debate, when clearly they couldn't possibly mean to vote for it unanimously. He then said immediately after that, quote, there are certain districts in the House that are black districts by law just about now. Which I don't think he meant to sound like, oh my God, black people are taking over, but that is roughly what it sounded like to me. And sitting right next to him, the Chief Justice, John Roberts, was as clearly hostile today, just without the gratuitously inflammatory racial language. I don't know if he likes the gasping as much. The lawyer arguing for Shelby County, Alabama, that the Voting Rights Act should be dismantled, said today in court, he said, I think the problem to which the Voting Rights Act was addressed is solved. He said, everyone agrees it's been very effective. Section 5 has done its work. What happened today is that the conservative majority of the Supreme Court signaled that they are going to dismantle the Voting Rights Act. Not on the basis of evidence that it isn't needed anymore. Congress assembled 15,000 pages of that evidence that it's still needed back in 2006. And after looking at 15,000 pages of evidence and taking 21 hearings and 10 months of debate, they decided to vote unanimously in favor of keeping it. The court seems like it has decided to kill this pillar of the Voting Rights Act today, not because of some new evidence that it isn't needed anymore. That evidence went to Congress, and Congress acted accordingly. No, the court signaled today, the conservative majority of the court signaled today, that they may get rid of this pillar of civil rights. The most important federal civil rights law that we've got, arguably. They signaled they may get rid of it, not because of evidence that it is not needed, but because they just don't like the whole idea of it. What good is it anyway? Civil rights leader and Congressman John Lewis himself joins us next.